Okay, shall we make a start? So, morning, all. Welcome to one of Ignition's commercial conversations series. This one is protecting your brand, trademark protection essentials. Serena, a senior consultant here at Ignition, is going to talk to this. The commercial conversations series that we do, they really sort of a commercial series in nature. They're designed for SMEs, scale-ups, startups, really to give some insight on key business topics. And the emphasis is on us giving some practical advice and helping businesses navigate these challenges. So I'll hand over to Serena. Thank you.
Well, good morning, everybody. It's very nice to have you all here. For those of you who don't know me, my background is both in-house and in private practice. And in-house, I've been lucky enough to work with a large number of international and FTSE 100 companies. So I've done various things like setting up the ATP tennis tour and other sports stuff. I worked for Guinness, and all of these things were global. I worked for Bailey's through the rebrand, Disney, including ABC News, O2, which is my favourite brand of all time, and Telefonica, where I ended up head of IP for everything, including O2. So you might think, well, how is that relevant to us? Because we're just SMEs and scale-ups. But the answer is trademark law is the same, regardless of the size of the entity that's talking about it. And the experience that I had in developing trademark strategies and enforcing trademark portfolios globally is really useful when it comes to advising small companies and early stage companies on what sort of things to look out for to avoid difficulties later on relating to their brand. So I think the first question to ask is, what is a brand? And essentially, I'm going to make a distinction, as you'll see from the slides, between a brand and a trademark. So a brand is your business, and it's the name of your business, and the brand is the attractive force that labels your business so that people think, oh, I'll go and buy a Kit Kat because what I want is a chocolate covered wafer bar that has fingers to it. So the brand is everything about your brand, not just the trademark. So it includes the name and the get up, the tone of voice, the way you approach your customers, who your customers are, what your brand looks like visually, as well as what it looks like in terms of the name. So I thought it might be worth having a look at one or two brands. So the first one I was going to look at is the Guinness brand, which is the next slide, please, Tammy. So you can see here that this is a screenshot of a number of images of different Guinness marks. And there are a couple of things here that I would point out to you. One is the name is consistent and the harp is consistent in almost all, no, in all of these screenshots. But when you look at the detail, the way the Guinness is written, so the logo, the typeface, the spacing, the color, everything else does vary. Now, this is a screenshot of marks, one of which is a fake. The others of which are taken over time as the mark has developed and used different presentations to modernize their appeal to their customers. Some of them are the same, but in different colorways. So we've got some on a black background and some on a white background that are the same. And I think in about half of these, the harp is one design and the other half is, oh, Lauren has just said something.
Yeah, sorry, Serena, I can't see the slides. I don't know if it's just an issue that I'm having.
Oh, can everybody else see? Is there anybody else who can't see the slides?
Just me then, no worries.
I think it might just be you. Sorry, Lauren. Other people can see them. So I'll share them with you later. So in terms of the drawing of the harp, there are two different drawings here. And again, that's because it evolved over the years in response to the brand and marketing team's requirements to update and modernize the mark. And that's quite an important point that I'll come back to later on when I talk about using a mark as it's registered. So just hold that thought for the moment. And if we look at the next slide, which is the O2 marks, it's the O2 marks with a message from Helen Slater on the top. Apologies for that. A whole lot of these marks are in fact knockoffs and not genuine O2 marks. And I spent a lot of time at O2 making sure that we chased after people who were using imitations of our marks, and for that matter, people who were working with us, but who took their own version of the logo and sort of tweaked it for themselves rather than going through the brand team. So of the ones that are here, clearly the ones that are in green are not ours. The second one in the top line is also not ours. That was one that somebody took and tweaked for themselves, as is the fourth one in that top line. The first one in the second line, you don't see so much these days. It's usually used as a movement one rather than static. But that and the other two blue ones on that line are genuine O2 logos, as are the three at the bottom. So you can see that it's quite easy for somebody to produce something that's pretty similar. And sometimes it's quite difficult to know, particularly if you play about with your logo and use it in different ways. It's quite difficult to know whether you're looking at a genuine one or one that's been tweaked about. So, for example, look at the second one in the top line. And that's quite an important thing to remember, again, when it comes to use. And I'll come back to that at a later stage. I thought it might be fun also to have a sporting one. So the next slide shows the FIFA logos in their various forms. As you can see, FIFA use a very wide range of logos. They also use extensively a logo which is the image of the World Cup itself. And again, using a wide range of logos, but in slightly different colours and slightly different typefaces and slightly different formats over the years actually builds a strong brand. But if you try and do this at the outset before you've really built the strength in terms of recognition in your core brand, it can be quite a problematic thing to do. So I've said that what a brand is the attracting force, the thing that brings customers into you. But of course, what can happen, even with a very strong brand, and I would suggest that Tesla is a very strong brand, is that things can happen and go wrong, which damage your reputation, and by damaging your reputation, damage the brand value that sits with that reputation. And I picked Tesla because that's a recent example where several £billion were wiped off the company's valuation, the Tesla's company's valuation, because of Elon Musk's involvement with the current US government. And that's one of the reasons for highlighting that particular case. And the post office would be another one that I think would be relevant in this particular context, is that when you say, oh, do we have to have a license agreement which goes on for so many pages? And I do try and keep the license agreements in English, plain English, and as short as possible. But one of the reasons that we have to put some stuff in, or we recommend that you put some stuff in, is because if you license somebody else to use your mark, so the Tesla marks are actually owned by an IP holding company and the trading company is a licensee, and the licensee itself does something which damages the mark, you want to be able to get out of that arrangement with them. And you need to be able to distance yourself as quickly and as far as possible from any reputation damaging activities which are going to damage your brand and the value of your business. So moving on to the question, which is the sort of legal side of the brand issue, what's a trademark? Now, a trademark is much narrower than the question of what is the brand, because it doesn't include the imagery, it doesn't include the get-up, it doesn't include the tone of voice. What a trademark does is to protect a name or a logo, and it gives it there are two ways of protecting it under English law. All intellectual property rights, including trademarks, are geographical rights. So when I'm talking about trademarks today, I'm talking about trademarks in the UK. It's perfectly possible and relatively straightforward for a UK business that is trading in other countries to obtain trademark protection in other countries, but I'm not talking about that today. I'm talking about the basics of trademarks as they operate in the UK. So there are two kinds of trademark, registered and unregistered. I'm going to deal with unregistered first because I'm not going to talk about it again for most of this session. So an unregistered mark it's a label for the goodwill and reputation that you build up by using your name in your business. It's still made up of the same bits of brand as we were talking about a moment ago. That's the same whether it's a registered mark or an unregistered mark. But in the case of an unregistered mark, if somebody else tries to use the same mark or something very closely similar to it, and you want to stop them doing it, it's a much more cumbersome, lengthy, and very expensive process than enforcing a registered trademark usually is. And the reason for that is that in this country, this differs in other countries significantly. In this country, you'd protect your mark by an action in what's called passing off. And you would have to prove that you own the mark. You'd have to prove that you've been using it. You'd have to prove the extent of your reputation. And that would involve you in showing things like all the advertising and promotional stuff that you'd done over a period of 3 years or more than that, ideally. You'd have to show what you'd spent on promoting the mark. You'd have to show what your sales were. You'd have to show how well known and recognised the mark was in different places. And that's before you start showing that the other party is using your mark in a way which the law regards as unfair. That's to say, by making a representation which makes customers and potential customers think that you might be connected in some way. So that's a massive bit of litigation, and it's something that SMEs and scale-ups really do not want to put themselves in the position of having to do, because it's terribly draining on the resources of the organisation in terms of time, management time and effort, and it's also jolly expensive. So leaving unregistered marks to one side as an undesirable thing, but a fallback position if you haven't registered a mark, so there is some kind of protection. We go on to registered marks. Now, a registered mark is one where you have applied for and obtained registration at the UK Intellectual Property Office. So you have to go through a particular process, you have to pay some fees.
The reason that is because after trying to raise funding for SAVE.
I'm sorry, there's somebody talking in the background. Could whoever OT is put themselves on mute, please? A registered trademark is valid in the UK, so the whole of the UK, including Northern Ireland, but only the UK. It's there to protect what's called the essential function of a trademark. And the essential function is to guarantee the origin of the goods or services that are provided under that mark. And I'll come on at a later stage to talk about a bit more about the essential function and the guarantee of origin and the need to have an accurate description of the goods and services that are being provided. So the next question is, and we're looking at it on the next slide, does a startup need to register a trademark? Well, there are two answers to that question. One is yes, and the other is no. The way that you decide where you are in the yes and no is, first of all, you don't need to register a trademark to trade under a particular brand name. You're entitled to do that without registering a mark, as long as you're not trading using somebody else's brand name or something very close to somebody else's brand name, in which case you're in the infringement category. But if you've chosen your own name and it's distinctive and it's yours and it's not too close to anybody else's, you don't need to register that as a trademark to trade under that name. However, if you don't, there is always a risk that somebody else will register something which is fairly close to it, And down the line, when you get to the stage where you think, well, now I would like to register the mark, you'll find that it's either tricky and expensive because you've got to sort out the issues with the third party, or even that it isn't possible for various reasons. So there is an advantage to registering at the beginning in that you protect your position against third parties. That's to say, against third parties using something similar. You also put yourself in a position where if somebody came along and tried to do something that was almost identical and aiming at your customers for the same goods or services, instead of having to do the expensive passing off action that I mentioned earlier on, you do an enforcement of a registered trademark, which is a much more straightforward and usually a much more straightforward and much cheaper action. So if you found that somebody else was using your registered mark, the first thing you would do is send a cease and desist letter. That draws the other side's attention to the fact that you've got a registration and that you're using it for the goods and services that they're trying to use it for. And if there's a genuine inadvertence in what they're doing, people will usually back off at that stage. You may need to negotiate a little bit with them about, how long it takes them to take, to repackage and remarket and redesign their website. But essentially, that usually resolves even before the stage of needing to issue proceedings for infringement. With passing off, it's much less likely to get settled quite so quickly. So, do you need to register a trademark? No. Is it a really good idea? Yes, as long as you can afford to do it, at the point at which you can afford to do it, getting basic registration is a sensible plan. Now, you can also do a basic registration for your main name in your main categories as your starting position, and then add to that later on, because there is no time limit on when you apply for a trademark. So you might start with a basic registration because that's what you can afford to give you some protection at the beginning, and then expand it later as you've got more funds coming in and you're able to afford to do the additional protections. The other thing I just want to mention in relation to startups registering trademarks is that if you're trading in other countries, then registering a trademark here gives you 6 months during which you can apply to register a trademark in a large number of other countries, and you can still use as your starting date the date that you made the application in the UK, and that's often helpful if in the meantime somebody in the other country has applied to register the same mark, because yours will take priority over it and you will be likely to get the registration rather than them. One of the questions we often get asked is, well, I've registered my company name and that's my brand name. Surely registering the company name is enough for me to be able to stop other people from using it. It's not. All a company name registration does is to give you the right to trade a company under that name. And there used to be, but I'm going back probably 20 years now. Companies House used to do a bit of a check to see if you were applying to register Coca-Cola brackets number 3 close brackets limited, and would say to you, hang on a sec, I think this is too close to an existing company, namely Coca-Cola Limited. They don't do that anymore. So actually, if you applied to register Coca-Cola number 3 Limited, then the Companies House wouldn't do anything to stop you. They would allow you to do that. Having a company name doesn't give you any right against a third party to say, well, you can't use the same name. You'd have to do that through something like a passing off action. And as I've explained, that's really a bit hard. So registering your brand as your company name is not enough to stop others using it. It does give you the right to use it as your company name, and that's all. So moving on, I think the next question that a lot of people want to ask is, well, what's the registration process and what does it cost? So in terms of the process itself, it's a question of making an application with the UK Intellectual Property Office, and you have to give certain information to do that, and you have to pay some fees to them to do it. We generally recommend that you do this through a trademark attorney, because the question of whether your mark is, whether the mark itself is registrable and whether you've got the goods or services right is absolutely critical to whether you've got a trademark that does the job that you think it's doing. And for reasons that I'll come on to explain in a bit more detail in a minute, it's often quite hard to do that. It's a very skilled job and it requires quite a lot of experience and knowledge of background cases and guidance. So you can make an application yourself on the UK Intellectual Property Office. I simply don't recommend that you do, because the chances of you getting it right are relatively slim. And a lot of the things that we see as contentious issues are places where somebody comes along and says, well, I've registered my trademark and now somebody else is coming along and using the same thing and I want to stop them. And you look at it and they haven't registered it for the goods or services that they're actually using. They've registered it for something else. And the other person is using it for the something else and you can't stop them. Or what they've registered is a sign that they're not actually using. And again, after a period of time, that becomes a problem. So keeping third parties off your territory is something where the specification of goods and services in the trademark application is really important. So you make your application, what you tell the registrar is what the sign is, what the mark is that you want to register, what the name is that you want to register. So FIFA, for example. The trademark office will look, so that's the first bit of information. Then you tell them what goods and services you want to register it for, and then you pay the fee. That's the basic process. Then the Intellectual Property Office appoints an examiner, one of their members of staff, to have a look at your application and see, have you filled the form in correctly? If you haven't, they'll usually give you a chance to put that right. Although there are a couple of mistakes that you can't put right. Then they will have a look and say, well, okay, what is it that you're trying to register? FIFA. We'll do a search and see if we can find anything else that either is the same or is very close to that. And they'll search on the register and they'll find that FIFA itself has registered FIFA, and therefore you're applying to register something that would be the same as an existing mark. And on that basis, they will tell you that it's the same as an existing mark, and they will also tell FIFA that you're trying to register it. So you're likely to have FIFA coming down on you like a ton of bricks. Obviously, other organisations are smaller and less heavy than FIFA, but nonetheless, that's the process that will be followed. So if it's either the same as an already registered mark or similar to an already registered mark, and again, the question of what is similar is very much a question which is not obvious in the common sense way of looking at things. So things can be similar for trademark purposes that are not similar, that you wouldn't necessarily regard as being similar on an everyday basis. So the tests for similarity are, is it visually similar? Does it look the same? And is it orally similar? Does it sound the same when it's pronounced? And is it conceptually similar? Does it have the same sort of meaning to it? And the examiner will look at all three of those things in considering whether or not something is similar. But the first thing that they throw up on the searches are things that are visually and orally similar, because the search engines will pick those up. So we always advise clients, if they can afford it, and not everybody can, so sometimes you can't do this, to do a search before you make the application, particularly if your brand is critical to your business, because that way we can know before you make the application whether there's anything else that's similar. And if there is, you can have a look.
Calling about lot 702, I sent an email asking.
Could Lee Gratch please put mute on? Sorry, I've lost my train of thought. We always suggest that you do searches beforehand, because those will throw up any issues and you can deal with them before you make your application. That's worth doing if you can afford to do it and it's not cheap for SME in SME terms, and B, if the brand is absolutely critical to your business. Otherwise, one option is simply to make the application, let the Intellectual Property Office do the searching, because they'll tell you what the results of it are, and then deal with any issues at that stage. But that may mean that you have to withdraw your application, lose the costs of that first application, rethink and make a second application. So you've lost costs and time, but it's a perfectly reasonable process to follow if the search costs are prohibitive. So I've talked about the question of describing goods and services. This is really the sort of the core part of where trademarks often end up in litigation. So you'll see from the next slide that there's a thing called the Nice classification. This is a global treaty document, which was established by the Nice Agreement, which was made in Nice, surprisingly enough. And it classifies all goods and services that it can think of into 45 classes. It used to come out every 5 years, but recently it's come out every year so that they can update because so many more goods and services are coming in. And one of the issues that comes out of there being 45 classes, those are generally applied globally. So it's generally, and there's a real qualification to that generally, because it can vary in different countries, but essentially most countries will interpret the Nice classification the same way. The big places where it doesn't happen like that are China and the Middle Eastern countries, United Arab Emirates, and all those kind of countries where there really are significant differences. But for most other countries, it's more or less the same with minor tweaks. But having said that, it's not as easy as you think to work out which class things should go into. So looking on the next slide at class 9, this is a common one which I've picked because it's likely that a lot of you are involved in tech one way or another. And there are 2 classes that we almost always include in the registrations for any tech business, and they're class 9 and class 42. So I thought it'd be useful to have a little bit of a detailed look at those classes and just see what they include. So I've put up the class heading for class 9 here, and you can see that that's essentially for anything which is computer software and hardware. Now, one of the things that the law says, and this is an example of things being absolutely not obvious from a common sense point of view, the law says that computer software is goods. So classes 1 to 30 are for goods and 30 to 45 are for services. So class 9, being in the beginning bit, is for goods. So if you've got computer software, notwithstanding the fact that it's only ever on computers, there's never anything that you could pick up and touch. It's goods, and you need a class 9 registration. And then looking on at class 42, that covers software and other things which are stored on computers, but again doesn't. Sorry, could we go on to 42, which is the next slide? Thank you. So you can see that those are services relating to software. And it can be tricky to make sure that you have described appropriately what it is that you're doing to get coverage in class 9 and class 42. And if you get it in the wrong class, then it can be difficult or even impossible to enforce it. But again, slightly counterintuitively, in my view, platform as a service, which usually does involve actual physical servers, is a class 42 item, not a class 9 item, whereas you might think, you've got physical bits of hardware here, which is where the service is being provided. So it might be class 9, but not. So that's why I've said that looking at describing goods and services is not as easy as you first think it is when you look and say, well, I'm doing this and I'm doing that. One of the big issues in trademark law at the moment is using the description computer services as a description, which is legitimate, but it's not likely to be enforceable, or computer software in particular, not likely to be enforceable unless you also say what kind of computer software it is, what purpose is what its functionality is for and who it's aimed at. And that's a change in the last couple of years, which again, professionals will have picked up. So looking on then to the costs, I've on the next slide, I've said searching is quite expensive, and you can see what the costs are there. And you would typically want to search for a minimum of 3 classes because of this overlap between different classes that I've talked about. I'm sorry, the registration amounts are missing from the slide, but we'll fill it in before we send it to you later on. But essentially, for one class, it's about 660 plus VAT, and each additional class, it's about 115 plus VAT. So you can see that the searching costs are much more expensive than just going for straight registration, which is why if you're really strapped for cash, going for registration and finding out what happens is a viable option. So moving on then to what makes a brand name strong legally. There are a number of things, issues, and they're set out on the next slide. First of all, you need a distinctive name or logo. So the Trademarks Act actually says, and I'm sorry, it's on at slide 20, if it's possible to nip forward to that for a moment. Thank you. So the Trademarks Act defines what a trademark is. This is a registrable one. So it's capable of being represented, so it's got to be something you can present physically. It's got to enable the registrar and the public to be able to determine the clear and precise subject matter of the protection afforded to the proprietor. That goes back to this question of describing your goods and services very carefully, and making sure that it does cover what you're doing and what you expect to start doing over the next 5 years. And also to distinguish those goods or services from others. You can see that any attempt to get a monopoly right in a particular name for computer software would be too broad, because computer software can be something which is in the consumer field, it can be something which is in a business to business field, it can be something which is in a highly technical scientific field. And those things aren't going to overlap or bump into each other, even in circumstances where they may be doing something quite similar. Certainly not where the computer software is doing things that are wildly different. It also says that a trademark may consist of words, including personal names, designs, letters, numerals, colours, sounds, or the shape of goods or their packaging. Shape of goods or their packaging is often problematic, because if something has to be a particular shape in order to contain whatever it's containing, then it's excluded from registration in the next bit of the Trademarks Act. But what you can register as a trademark is much wider than just a word or a logo. I thought it was worth knowing that. When you get a trademark right, it is a monopoly right. That's the right to stop anybody else using it. So that's why the courts are quite quick to stop people trying to monopolise words which are in use in ordinary English conversation. And the leading case on it is one about the word treat, which was registered by British Sugar for some sticky chocolate flavoured stuff that you squirted onto ice cream, and somebody else applied to register it for sticky chocolate stuff that you spooned out of a pot to use as a topping to use in puddings. And what the judge said was the word treat is an apt word in ordinary English usage to describe something sugary and sweet that people might be given as a treat, and neither of you can have the trademark. So it refused the application by the second one, and it also revoked British Sugar's original registration on the basis that it wasn't distinctive. So that's why when you're looking at choosing a mark which describes what your goods or services do, that can actually be problematic in trademark terms. If we look also at the next slide at section 3 of the Trademarks Act, that goes on to explain what the things are that are problematic. So these are things that will be automatically refused registration. So things which are devoid of distinctive character, and that was what the treat case decided it was. So if, for example, you have a clothes shop that sells wedding gowns and you call it the wedding gown shop, you are not going to get a trademark registration for that, because there is nothing distinctive about that at all. Then on the other hand, if you called it Serena's Gowns, you'd be fine. because even though that does describe it, it's distinctive because there are not any, assuming, which I haven't done a search to check, that there are no other Serena's gowns already registered. So you can have something which alludes to what you do, or which calls it to mind. It just mustn't describe it. And sometimes that's a bit of a sort of fudgy borderline to get over. But we're used to talking to people about what they're thinking about and how you might choose one or another of your possible options. So the next thing that's not, sorry, I was still on section 3. You can't have marks which describe the kind, quality, intended purpose, value, or geographic origin of the goods or services. In sort of black and white law, that doesn't sound very complicated, but actually when you're applying that in practice, Haywards Heath Tea Shop, for example, is going to fall foul of that one. The exception to those rules are that if you've been using Haywards Heath Tea Shop for the last 30 years, and everybody knows exactly which shop it is that you mean, and that's you, then you're held in law to have acquired a distinctive character because of the use you've made of it. So if you use it for long enough, you may be able to get a registration on the basis that people now do attach that word or name to you. But you're talking about quite a lot of years to do that, so it's not a helpful strategy as a general rule. So going back to what else makes a strong trademark on slide 18, you also need to have, so you need a distinctive name, no other similar marks on the register, an accurate and detailed list of goods and services we've talked about. Then it comes on to what you're doing with the trademark, because you can get a registration which is quite nice and strong and brand new, but you need to keep it strong. And in order to keep it strong, you need to use it as registered. So if you've registered the O2 on a background which is a blue gradient with bubbles coming off the top right-hand corner, and you use it on a red background, although it's the same and you've still got the bubbles coming off the corner, the top right-hand corner, you're not using it as registered, and that won't be use of your trademark. It'll be use of something similar, but it will not be use of your trademark. And so you're not building up the reputation in your trademark to make it stronger by reason of the use that you've made of it. So it's really important, to be sure that you're going to use it the way you've designed it at the outset, and then B, if you decide you really have to make changes to that, to talk to us about what changes you're planning to make and how you're planning to do them, so that we can help you manage that process to keep your trademark strong, which could include applying for another trademark which is quite similar but different. And then you have to use the mark in the course of trade, so you have to use it in supplying your goods or services. You don't have to supply vast quantities, but you do have to supply some under your trademark in order to keep it valid. The more you do, the bigger the reputation is that you build up and the stronger your trademark is. And then the final thing you need to do in use is to enforce the right against newcomers. Because if you don't do that, other people will build up the rights in it. And that in particular includes licensing people that you've given permission to use your trademark. And a trademark license must be in writing. It's one of the relatively few English law contracts that must be, as must the sale or assignment of a trademark. So it's really important that you have a license in writing in order to preserve the validity of your mark, because otherwise there's a risk that whoever is doing it will acquire the right to use it without your permission. It's also important, going back to what I said about brand reputation and damage, so that you can control how the mark is being used, and make sure that if whoever it is does something which you consider to be damaging, you've got the right to be able to sort that out one way or another. So moving on to slide 22, another thing that comes up quite often is the question, what's the difference between a word mark and a stylized word mark, and when does it matter? And I thought I would show you. So the next slide shows you a word mark, which is Clubcard. You will be unsurprised to know that that's registered by Tesco. And then I'm going to show you a stylized word mark on the next slide, which fairly obviously belongs to Lidl. You can argue that that's a logo or that it's a stylized word mark, but because it's got a word in it, it's pronounceable, it will be treated as a stylized word mark. It may also be treated as a logo. You may well have seen in the press that what happened was that Tesco started using Clubcard on a blue square with a yellow circle in the middle of it for Clubcard price. And Lidl said, this looks frightfully like our stylized word mark. Tesco said, well, it's okay because the only trademark in what we're doing is Clubcard, and we've registered Clubcard as a word. So, if it's registered as a word, we can use it however we like, as long as we're using it as a word. It's not a stylized version. And the court said, actually, what you're doing is producing something that is designed to and does look like Lidl, and to mislead or confuse people. And Tesco said, blow that for Game of Soldiers. We don't think that's a very good decision. We think it's a rubbish bit of law, and you've made the wrong decision. And actually, we should be entitled to use our word like this. So they went to the Court of Appeal and they lost there too. So why does it matter? Yes, it does matter. And one of the reasons it matters is that if Lidl had only got Lidl the word mark, they wouldn't have been able to enforce that against the Clubcard price campaign that Tesco ran. So the next question that comes up from time to time is the one about somebody else using a similar name to yours, but for services aimed at a different customer segment, so there won't be any confusion. That's a really tricky and fact-dependent question. The confusion in law is different again from confusion in common ordinary language. So you can find that there is an issue there, even though you're using what you consider to be different, you're aiming at different customer segments. So, for example, we had a recent case that came into us of somebody using almost exactly the same name. It was just laid out slightly differently. One of them was aiming at business customers, one of them was aiming at consumer customers. But the registration of the earlier mark, the one aimed at the business customers, covered the possibility of consumer customers. The mark had only been registered for 3 years, so they were entitled to protection for use for consumer services, even though they hadn't started doing that, because you get 5 years from the date of your registration to start using the mark on all the goods and services that are described in it. So again, as I say, very fact specific, this one, but it doesn't mean the fact that you're aiming at different consumers doesn't necessarily get you out of jail free. There may still be a real infringement problem there. Then the other question we often get asked is about funding rounds, and the investors asked about trademarks and what are they looking for? Well, what they're looking for is whether you've got the protection for the assets that they're planning to buy or are planning to invest in, that mean that the value of those assets will not drop because you don't have the right kind of intellectual property rights and somebody else challenges it. So that goes back to the choosing a strong mark, using it, registering it. And if you're doing all those things, then you're going to keep the investor happy, both because they'll be, when they do the due diligence on the intellectual property side, they'll get the right answers, but also because what it shows is that you take doing business seriously, and you're sensible and prudent about the way you run and manage the business, which gives you brownie marks elsewhere and increases the confidence of the potential investor. So that I think brings me up to around about my 45 minutes. The next 10 to 15 minutes is for you to ask any questions that you want to ask. I don't know if there are already any questions in the chat. Are there, Tammy?
No, not at the minute. But if anyone
Okay.
wants to sort of pop themselves off mute and fire away.
What's the optimal time? Thank you, Serene. That was great. What's the optimal time as a bit of a jack of all trades corporate lawyer? There was a case yesterday where a scale up with a decent budget, but quite limited nonetheless, was kind of trying to work out priorities. And their view was trademarks need to come a little bit in phase 2, kind of getting their company structure right, getting registered with the ICO, getting a shareholders agreement sorted is sort of step 1, or tidying up their version 1 of a shareholders agreement. What's the kind of optimal time? I mean, ideally straight away, but where budgets are limited, what's an optimal time to start to move from invoking copyright and and more common law IP protection into having proper trade and registered marks?
That's a really good question. There isn't a single answer to it, because it depends on, to a considerable extent, what the business is and how dependent it is on its brand. The more core the brand is to the business, the earlier you need to look at doing the trademark registrations. So I think you said registering with the ICO was a higher priority. Clearly it is, because failure to do that's a criminal offence. So you should do the things that it would be a criminal offence not to do first. That's always a good plan, I reckon. After you've done those, if you've got a shareholders agreement, the question is, are you going to tidy up the next shareholders agreement for the investment round? Then you're into the balancing act. Well, will the investor be swayed more by my having protection for the assets that they're planning to invest in, or by my having a tidy shareholders agreement or an appropriate shareholders agreement for the shape of deal that we're trying to do? And that will depend on the investor that you're talking about, the shape of the round one type shareholders agreement, the extent of the changes to that would be needed to make it suitable. And as I say, the importance, the significance of the brand to the business. The more significant the brand is, the more I would give that priority over tidying up the shareholders agreement. But it's a tricky decision to make, and there's no one size fits all answer to that.
Thank you, that's really useful.
There is a further question in the chat, Serena, which is what would happen if you want to change or add to the criteria covered by the original trademark?
You can't add to the protection that's already there. So if you've registered, for example, so that you cover biscuits in your first in your existing application, and you think, well, actually I do cakes as well, so I want to do biscuits and cakes, you can't say and cakes. So in that case you have to make a new application for a new trademark, but it would go through fairly straightforwardly because it would be the same as the earlier one in all the respects except the additional goods or services. But that's why making sure you've covered all the goods and services that you are going to do when you make your application, and that you reasonably think you're going to do in the next 5 years, is an important thing to do, because it saves you the costs of that second application if it's not necessary. Sometimes the world moves on and stuff is invented that didn't exist when you made your application, even though it was only 18 months ago. And then you're just stuck with it. You do just have to make the new application. If you want to reduce the goods or services that are covered, you can do that. And sometimes you will want to do that if you're in conflict with, or potential conflict with, another party, and there's stuff in your registration that you now know you aren't going to want or need. Reducing it is an appropriate technique to use there. As far as the name or logo itself is concerned, you can't change that. You would have to make a new application. So if you look, the first Guinness trademark was registered in 1759, or was it 1859? No, 1759, and they've had lots and lots of registrations since. Now, once you've registered a mark, it remains valid forever as long as you pay the renewal fees, which are every 10 years. So you don't have to make a new. It doesn't run out. It's not like a patent which would run out. But if you're tweaking how you're using it, then topping up your registration with the extra tweaks is a good idea. And one thing that we did in big companies, this is not likely to be an issue for you very early on, but as time goes past, you look at your portfolio and think, well, I've now got 12 marks. Do I still need all of those to protect what I'm doing? And that's a whole new ball game to think about that strategy. I think I saw another question in the chat.
Yeah, it's how would you suggest prioritizing the jurisdictions that you register your trademarks in? Example, sales, competitors.
You don't have to specify sales or competitors. I'm assuming jurisdictions means
Yeah, I think it's more of a, how do you decide which jurisdictions to register trademarks in? Do you make that decision based
Oh,
on?
okay, thank you. Yes. Yes, sales and competitors is a good way to do it. I would always recommend, if you're a UK company and you're trading in the UK, I would always recommend doing your UK application first, because a UK trademark registration is widely well regarded globally as being a jurisdiction where where the Intellectual Property Office looks carefully at the applications and only lets things through that should be registered. So it's a very, it's a nice strong jurisdiction to have your base mark in. That gives you the 6 months to think about the other jurisdictions, and then it's a question of where you're doing most business, or where you're doing some business, but you can see there's an immediate risk from a third party or a competitor. There isn't a right answer to that, because it's fact dependent, but it's a really important thing to think about. The other thing in terms of strategy for expanding jurisdictions is that there's a system called the Madrid Protocol, which allows you to make one application for trademarks in a number of different countries and saves you costs. So that's one of the things that we can look at. And sometimes you can add on 2 or 3 extra countries that way without it costing any more. So that's part of the consideration that you would also want to look at. And of course, if you're talking about Europe, as in the European Union, there is a unitary mark in the European Union. So you can apply for one mark and it covers all countries in the European Union. And that's a very significant saving of costs. Al has asked, what are the rules generally in the UK around use and proving it? Do you have to use the mark to make a successful application or claim for infringement, e.g. if you're pre-revenue? No, you don't have to. The rules about use are that you have 5 years from the date of registration of your mark to use it in the course of trade and as registered, before it can be revoked. And in the meantime, you can still enforce it, even though you're not yet using it because you've got a registration. It doesn't look great either in the Intellectual Property Office or in court if you're not using it at all and you can't explain why you're not yet using it. But if you've got a story to say, look, here are our plans, they're quite well advanced, we just haven't actually got to the stage where we've pushed the button on the website and started trading yet, then that should be no problem at all.
Great, thank you so much, Serena. It was really interesting and really insightful, and it's always good to see those practical examples. So thank you so much. Just to flag everyone, the next session we've got coming up is on the 24th of June. It's on real estate financing and joint ventures, trends and insights. So that's with some of our finance team and our real estate team. So keep an eye out in your inboxes for an email about that session. But thank you so much again, Serena.
You're more than welcome. It was lovely to talk to you all.